All right, so I want to welcome you to Legacy Legal and Consulting Firms Legal Pop-Up. We are in March 7th, 2025, and this is the Q&A session. All right, so I am going to permit you can unmute yourself and ask your questions that you have.
Quick comment. This is just absolutely fantastic. Thank you.
No problem. No problem. Thank you, Jeffrey. All right. Crystal, did you have a question? If not, I'm going to pull up the questions that some people did ask. All right. Okay, so I had a question. Oh, you did have a question that you submitted. It says, I have content, books, and branding. What's next? So the content that we just went over, essentially, depending on what you are going to license, you want to make sure that you register for protection first and then get a clear, well-detailed contract in place. So I gave you some outlines of the contract, but you really want a clear outline about what they can do with the books. Can they print it? Can they distribute it? Where can they distribute it? What are the parameters around it? You want to make sure that any of your books have what I call a legal notice in it, just letting them know about the copyright parameters and permissions that are there. One of the things that I write into my digital books is I also write in where they can email for permission. So I had a free ebook that I had gave out called 8 Things You Better Hope Your Contract Covers. And a CFO wanted to distribute it to their clients. And so they followed the instructions that was already in my ebook to request permission. So that's another area that you can, it was an unofficial license, but because it's in writing in my email, that's what it is. So that's another way that you can also create avenues to license your intellectual property. But essentially, you want to have a contract. If this is something that you're going to be doing standard, you can even create a standing contract depending on what you are going to be doing. So I hope that answers your question. Okay, the next question we have is, okay, so Asia asks, I'm a content creator and I love to learn how to license my IP in the social media space. I'm not sure what questions to ask. Okay. All right. So depending on the content that you have, if you're a content creator and you're looking to license in the social media space, you can do one of two things. There's a difference between having a service where you're creating content for someone and then having the licensing terms that are part of that service. So maybe if you are creating, let's say you have a bundle of content that you create for social media, maybe you have templates or you have like a framework that you have that they can use to create their own content that actually generates leads. Then what you do is, as a part of the purchase in your terms and conditions on your website, is where they can check that box. This is how you create a contract on the website. They check that box to accept your terms and conditions. And in the terms and conditions is where you can actually put your licensing terms. And in those licensing terms, this is where, depending on what you want, you put in there that one, they can never sell it. They can never sell it. They can use it for their own business. If it's not going to be a royalty situation, then that fee that they pay, that fixed fee, is what they pay. But that's where you put all of the restrictions in there. Now, if you're creating templates or maybe you're creating a template library, then this is where you want to talk about, let's say, I'm just gonna throw out an example. Let's say that you have a content creation library where they pay a licensing fee to get access to all of your creative works for a year, and then after the year over, the subscription starts over again. Now, it's a part of licensing, but it's really a subscription program, and so you also want to make sure you follow all the laws for subscription, it's called zero option billing by the FTC. They have particular laws that you have to follow in terms of notices, opt-out, cancel procedures, all of that. You're going to do that way because there's more than one way to license IP. That's not the standard traditional, oh, here's a contract, let's negotiate it. You can also create a subscription program where people can get access to your content creation. Maybe you even do, some tutorials in there. And every year, every so often, every quarter, they're paying that licensing fee to get access to it and use your works. But within your terms and conditions, that's where you put your licensing terms and conditions of what they can and cannot do. And if necessary, or if you wanted to, you can even do for some of your content, you can even do a attribution or contribution. You've probably seen, if you go to download royalty photos or videos, they'll say that you have to attribute the author. That's the same thing. You're still licensing, but what it is that now you have to put a credit to the author. You can do that for some of your content as well. And then there was one other question that popped up, and give me one moment. It was about roadmaps. This person registered actually today, so I want to make sure I honor that question. If you have any questions, you should be able to unmute, and if not, just let me know and I'll give you the right to unmute. Make sure I answer everybody's questions, and we gonna wrap it on out because I am definitely, we're at the hour time, and now I know to create an hour for legal pop-ups. All right, here we go. Okay. I think it was Nicole. All right. So Nicole asks, I sell roadmaps, plans that take you to a specific goal. How do I protect them? I want to sell strategies as well as sell its structure so that clients can buy both the strategies and the clients on my formulas. How do I protect this? Okay. So formulas are not protected. Formulas are not protected. If you have roadmap plans, what you can do, if you have the template for the plan that you always use, you can protect the format of that, not the formula, but the format, by doing a copyright. So you file copyright registration for that. And then when it comes to the strategies, that's something separate. So if somebody is, you can still have it as two separate things that they buy. So the roadmaps copyrighted have your licensing terms and conditions within the roadmap, like legal section, this is what I call it, and in your terms and conditions and your sales. That is that one license piece, but depending on how you're going to license it. So if they're paying a fixed fee, that's just a fixed fee. But if you're doing royalties, then you need to set it up correctly, because with royalties, you want to make sure that you, depending on who you're licensing this to, that you have access to keep, because if it's digital, once they get it, they have it, right? That it doesn't stop anybody from ghosting you. This is why the contract is so important. But when it comes to having their information, subscription billing, being able to bill them over and over again, if their card expires, again, this is where you want to have, I didn't put this up there because this is another piece, but when it comes time for like working with people in contracts, you want to make sure that you actually have their details, not just their business details. You want to be able to track them down. And so one of the things that I teach is people are always on friendly terms when you're at the beginning of the contract, when money is really well. This is where you want to be as wise as a serpent and harmless as a dove. And you say, look, there's so much going on in the world. Accidents happen. We just, COVID was a big thing. I think there's more things happening. And so if there is ever an issue where we cannot contact you, who's the top one or two people that they know how to get in contact with you? You want to get all of their information. Why am I telling you this? Because if you ever need to sue them, these are the top one or two people that you can give to your attorney to track this other person down. I'm telling you this based on previous experience where one of my clients, somebody took $20,000 from them and then ghosted them and tried to skip town. Absolutely not. They won. They finally won their victory in court. Six-figure, they got $100K settlement back. But they had, in order for you to be able to serve somebody papers to get them in court, you have to track them down. And this is why you want to know not just the person's business address, and you want to check it in the state registry database, but you also want to make sure that you get their home address and then get an emergency contact, one or two people that know them, and then collect some social details that they tell you over time. This is just to cover your behind. So if you need to go sue, you can. But for Nicole, Depending is how you structure it. So licensing, depending on what you're doing, is really how you structure your business and access to the information. If this is something where, once you sell it, you can't control it, then you don't really have control over access. And that means you need to set up your business properly to control access if you really want to control the royalty payments and control your intellectual property. All right, okay. Crystal, I believe you should be able to unmute yourself. Okay.
Yes. Hi, thank you. This is great stuff, and I am going to follow up with you really quickly. So there is a proposal out there, and they have a section in the proposal, this utilities company, and they want ownership of documents. And they say things like, upon completion of termination, prepared by us, the consultant, it becomes the property of this organization. They also say, any reuse of the materials related to the services without prior verification or adaptation by the professional is for the specific purpose intended for that organization, and they will assume sole risk without liability to the professional. One more thing. They also say, where applicable, the consultant shall retain all pre-existing proprietary rights in the materials provided to this company, but shall grant to this company a non-exclusive, perpetual, royalty-free license to use such proprietary information. And I'm like, no. So how do you, because I do want to do work, but how do you, because there's a Q&A session right now. So we're asking about that. So I didn't know if you had like quick.
Yep, you're fine. So this is something, so I don't mention this, so I do multiple things. I also coach CEOs on DIY legal. And so some of my CEOs in that membership do government contracting. And one of the things I have to tell them is, if it's a government organization, chances are you're not going to have leverage on how to negotiate out of their intellectual property terms. But when you know the rules and understand the rules, you can get around it. Okay. Is the organization a government organization?
No, it's a utilities, public utilities company.
Oh, then you have room to negotiate. You should be able to negotiate.
In Texas?
So from what I understand, there's a part there that I didn't catch, but essentially what they're saying is, if you create it during the relationship, they own it. But if you created it before the relationship, you maintain ownership, you just give them a license to use.
But they said royalty free and perpetual.
Which means you ain't gonna get paid for it. They get to use it free and clear. So yep, this is where again, you have to be wise as a serpent and harmless as a dove to identify what part of your intellectual property are you okay with allowing them to use, and which part you are absolutely not okay. Because remember, there's a difference between, depending on what you're doing, there's a difference between consulting, which means ain't nothing in writing. Are you catching on to me? Nothing's in writing. Which means if it's not in writing, there's no copyright. Did you catch that? Nothing's in writing. It's still all in here. It's you're the skill, but you're not putting it in writing. You're consulting with them. Now, if all of your material is proprietary, you already have, then this is where you have to identify, this is where you have to identify whether or not you want to modify the materials to take out some of your proprietary information that you absolutely don't want to license, or if you're okay with allowing them to continue to use it later on.
Okay.
This is where you have to be strategic in your business practice, meaning you're still giving them great service. You're not skipping out on that, but you're being very strategic about what you allow to be put in a copyright protected format versus, let's be honest, many of us have done business. I've worked for the government before. They're not going to remember what you tell them.
Right.
Which means if it's not written down, if it's not in a presentation, if it's not in a recommendation, it's just verbally written, you can tweak how you write it down so that you protect your intellectual property, but still give them great service.
Okay. I'll be calling you. Thank you.
there's just, you just have to be very strategic in how you do it. That's all. But there was another part in that I heard that it sounds like they're trying to put the liability on you while still keeping the right to use your intellectual property. But I wasn't sure what I heard, but that's what it sounded like. All right. Well, that's it for the Q&A section. Oh, give me 1 second. Let me allow for you to unmute yourself, Crystal. Thank you guys for holding on and staying to the very end. Next time, I'm just going to give a whole hour for our legal pop-up.
I am back. So I think you were asking where it said any reuse of the materials related to the services without prior verification or adaptation by the consultant for the specific purpose intended will be at the company's sole risk and without liability to the consultant. So that's where they mentioned the liability. So I guess if they take my content and they do with it and run with it, it won't be, that'll be the company's sole risk and without liability to me. But
yeah, it's worded. I would, yeah. So things like that, I would have to see the entire section because attorneys can get very, I mean, I've done it myself. You can get very creative in how you word certain things,
right,
to make sure that you're protecting certain interests. So yeah, for you, it's going to be a matter of if you want to use your prior intellectual property, editing it or modifying it in a particular way that it can be adapted and used for them, but you still keep the core of your
right,
intellectual property. And because oftentimes what will probably tend to happen is they're going to ask you to put it in writing or to do something. And this is where you're going to have to get creative to not give away all of your juice, so to speak, your secret sauce, so that they can't, again, without seeing it, so they can't prevent you from using your intellectual property moving forward.
Okay.
Yep.
This is good stuff. Thank you.
All right. Well, that's the end of the Q&A. You're going to get access probably by Monday to both recordings. So you'll have access to the recordings. I don't right now, I don't do a limitation on replays because I recognize that first and foremost, you guys are probably, we as business owners, we take many classes. We don't have the ability to remember everything. So you will have access because you registered to the Q&A portion. Both will be put up on YouTube. You will have the unlisted link to the Q&A portion, so please don't share that, but everybody will have access to the main content that was a part of the first recording. So you'll have that. You'll get that email by Monday at the latest. And if you're on the email list, you'll also be receiving an email from me coming soon once I nail down what has been the back and forth with the Corporate Transparency Act and the new legal developments that has transpired within the last week. So you'll have access to all of that information. Thank you so much for registering, staying with me over time. And I hope you both have a wonderful, wonderful rest of your weekend. Again, if I think about what I was going to tell you, I will send that into an email directly to you once it comes back to my memory. So you guys have a wonderful rest of your Friday. All right. Bye-bye.